Rose v. State. This is a case from 1982. The question is, what can we learn from this case? Well, we're going to find that out right here, right now. This is Russell F. Rose was appealing a decision to the Court of Appeals in Indiana, 2nd District, back in February of 1982. So what was going on with this case? Russell Rose appeals his conviction of battery, which was a Class C felony at the time, and he's alleging that the trial court erred. So he's originally indicted for murder. He ended up being convicted of battery. So the main reason Rose was appealing this case is, one, trial court failing to give the jury certain tendered instructions on the issue of mistake of fact. Number two, trial court improperly limiting cross-examination of a state's witness. And number three, trial court imposing a manifestly unreasonable sentence. This appeals court decision, they remanded for further proceedings involving the sentence, but in all other respects, they affirmed the judgment. So this appeal didn't do a whole lot other than affect the sentencing of Russell Rose. So here's what's going on with this case. Back in May of 1980, Stephen Williams drove into a service station, and it was owned and operated by Russell Rose. And Williams asked an attendant to give him $10 worth of gas. When the pump reached 9:33, Williams told the attendant that he said he only wanted $2 of gas. So the attendant and Rose's wife offered to siphon the difference, but Williams refused. So at this point, Rose's wife called Russell Rose to come over, and it was suggested that Williams leave his car, get enough money to pay the bill, and come back. Well, Williams didn't like that very much, responded with profanity, spurned the offer, and remained in the car. And then Williams started to pull away with Rose running along the left side of the car, touching it near the driver's door. Williams then cuts his wheels sharply to the left, and Rose, who had produced a handgun he was licensed to carry, fired one shot. The bullet struck Williams in the head, resulting in his death. Rose was indicted for murder, but ended up getting convicted of a Class C felony battery. He was sentenced to an executed term of 7 years imprisonment. So the bulk of what we're going to look at here is what Rose is appealing. He is claiming that error in the trial court's refusal to give his tendered final instructions. And basically what happened toward the end of a trial, the judge will allow jury instructions to be given to the jury before they go deliberate. And they had a few put together that the trial court ended up refusing. And we can learn a lot from why the trial court refused these instructions, because these instructions are a very good example of the law being misunderstood. So the first thing this decision does is it kind of lays out the criteria that they use when they're determining whether there's a reversible error results from the failure to give these tendered instructions. So number one, the main rule is, does the instruction correctly state the law? And this is very problematic here for Rose. Number two, is there evidence in the record to support the giving of the instruction? Is it even necessary? And then number three, is the substance of the tendered and refused instruction covered by any other instruction that's already been given? So those are the basic criteria that this appeals court is using, and they base that on Davis v. State from back in 1976. So the question that I pose to myself and want to create this video to support Indiana responsible gun owners is, what can we learn from a decision like this? What are the legal mistakes that you and I don't want to make? Well, let's look at this first refused instruction here. This is the instruction Rose's defense team wanted to give to the jury, and the trial court said, no, you can't give this to the jury because it's an inaccurate statement of the law. So what is it they did, or what did they say here that was so inaccurate? Here's what they wanted the jury to hear. If the defendant, Russell Rose, reasonably believed that Stephen Williams was committing a felony involving the imminent danger of bodily injury to a human being, so that would otherwise be known as a forcible felony. If Russell Rose believed a forcible felony was being committed, and he reasonably believed it was necessary to use deadly force to effect the arrest or prevent the escape of Stephen Williams, then under the law, he was privileged to use said force, even if he was mistaken in one or more, or indeed all of his beliefs, and under such circumstances, he would be entitled to an acquittal. So the gist of this erroneous instruction: if Rose believed that Stephen Williams was committing a forcible felony where another human being was in imminent danger, and if Rose reasonably believed it was necessary to use deadly force to effect an arrest or prevent the escape of Stephen Williams, that's the big problem there, then under the law, he was privileged to use that force. So that is not the case. The trial court properly refused the instruction as an inaccurate statement of law. Tendered instruction number 2 erroneously states that deadly force may be used to effect the arrest or prevent the escape of a person committing a forcible felony. What we're going to find out here is, yes, we do have a citizen's arrest statute in Indiana law, and we are allowed to use reasonable force to effect an arrest or prevent an escape, but we're not allowed to use deadly force unless somebody's in imminent danger at the moment of being harmed or killed. We can't use that deadly force to effect the arrest or prevent the escape. We can only use that deadly force to prevent someone from being harmed or killed. That's the big lesson from this particular instruction. So this appeals court goes on to explain, specifically provides deadly force may be used only as provided in, and they don't put the number here, I don't know why, but it's 3541.32 right there. And it specifically provides deadly force is justified only if a person reasonably believes that their deadly force is necessary to, number 1, prevent serious bodily injury to themselves or to a third person, or number 2, to prevent a felony involving the use or threat of force against a human being or imminent danger of bodily injury to a human being. So that right there is the definition of a forcible felony. So what they're saying here is that deadly force can only be used to prevent serious bodily injury or to prevent a forcible felony, which is exactly what the statute says. They're basically just summarizing this statute. And here is the exact statute, 3541.32, and this is subsection C, says a person is justified in using reasonable force against any other person to protect the person or a third person from what the person reasonably believes to be an imminent use of unlawful force. I call that the reasonable force sentence. And then we go to the second part here. However, a person is justified to use deadly force and does not have a duty to retreat. That's our stand your ground phrase or provision. You're justified to use deadly force if you reasonably believe that that force is necessary to prevent serious bodily injury to the person or a third person, or to prevent the commission of a forcible felony. This first sentence is the reasonable force sentence, and then this second sentence is the deadly force sentence. And that's the statute that they were quoting in their opinion here. So based on that statute, then the big key lesson here is that deadly force may never be used by a non-law enforcement officer to effect the arrest or prevent the escape of a felon. The justified deadly force is to prevent injury, not to arrest somebody or hold them in place and wait for the police. We're only allowed to use deadly force to prevent injury or to prevent the imminent danger of injury or force, which is the forcible felony, or the threat of force, not to effect an arrest or to prevent the escape. So consequently, they rejected that tendered instruction as erroneous, and the appeals court said it was correctly refused by the trial court. Well, we just looked at the justifiable use of force statute, and that statute is 3541.32. So we just looked at that. Well, let's go down to the very next section. The next section is 3541.33. This is the section that does talk about arrest or escape. What are we allowed to do? What are responsible gun owners allowed to do who are not law enforcement officers? And that's what this statute speaks to. So let's look at it. Under subsection B, it says a person other than a law enforcement officer is justified to use reasonable force against another person to effect an arrest or to prevent the other person's escape if a felony has been committed and there's probable cause to believe the other person committed that felony. However, such a person, meaning you or I, is not justified in using deadly force unless that force is justified under Section 2 of this chapter? Well, remember here, we're talking about the use of force relating to an arrest or an escape. That is section 3 of this use of force chapter. Coming back up under section 2, which is what this number represents, that's the use of force statute that we just looked at a moment ago. So the point is, under the arrest and escape statute, which is section 3, it says we can use reasonable force, but if you want to use deadly force, you got to go back up under section 2. That's where you're allowed to use deadly force. And what does that say? It says you're only justified to use deadly force to prevent serious bodily injury or to prevent the commission of a forcible felony. And what is that? A use or threat of force where there's an imminent danger of bodily injury. So we're only allowed to use force to prevent bodily injury. We're not allowed to use force to affect, we're not allowed to use deadly force. We're only allowed to use deadly force to prevent bodily injury. We are not allowed to use deadly force to effect an arrest or prevent the escape. What does this mean? That means if you see the forcible felony happening and you can use deadly force to prevent that forcible felony, that's one thing. But if you just witnessed a forcible felony and they turn around and they're running away, you cannot use this deadly force to prevent them from running away. You can use the deadly force to prevent the forcible felony, but you cannot use deadly force to prevent their escape. That's a critical thing that we need to get right. Too many people in my classes think they're allowed to use deadly force to arrest somebody or prevent their escape after witnessing something terrible. And you would think it would be right to use deadly force if you just saw somebody stab somebody and they're running away. Well, you could use that deadly force to prevent that stabbing, but you can't use deadly force to arrest them or prevent their escape. This is something we cannot afford to get wrong. There's one other jury instruction that got refused that I think is very revealing, very educational for us to understand. I love this dialogue. It explains the philosophy of self-defense law. So this jury instruction that was refused, the complaint from the Rose team is that the trial court erroneously refused this instruction. So let's look at what this instruction said and what the appeals court has to say about it being refused. The instruction said that determining whether or not you may use deadly force against one he believes to be committing a forcible felony, a man has a right to act upon appearances of actual danger if he reasonably believes such apparent danger exists. The danger need not be actual. It need be only apparent to a reasonable person under those circumstances. The law protects persons who feel compelled to act at such times, even though in retrospect, it is proved that they made a mistake, they erred. The law takes into consideration all the surrounding circumstances under which the events took place. So this is the concept of reasonable mistake, reasonable belief. And the trial court refused this instruction, and the appeals court disagrees not with the instruction. They don't disagree that the instruction was bad law or anything. They disagree because they conclude that the substance of this instruction was already covered by other instructions. That's one of the criteria. The court doesn't have to accept a jury instruction if they feel it's already been covered. So this is why the appeals court says, no, it was okay to refuse that instruction because that information's already been covered. And when they say it's already been covered, what do they mean? What's the main issue at stake here? The main issue is whether the jury was informed that a reasonable mistake as to whether force was used or threatened against a human being, or as to whether there was an imminent danger of bodily injury to a human being, does not preclude the self-defense justification. So if you make a mistake in your use of force, or in assessing the threat that you're using force against, it doesn't guarantee you're not going to be able to argue self-defense. The argument of self-defense, the fundamental basis of self-defense argument is the idea of justification. You were justified to use the force that you used. And what this is saying is, you can be justified to use force even in some cases where you made a mistake, as long as that mistake a reasonable and prudent person would have made. And so what the appeals court is saying is that that instruction was already given to the jury. Even though this is not badly stated law, it's not really erroneous, it's redundant. And the reason is because the trial court gave this instruction number 15 at the trial. So what did this instruct? Now, this is the instruction that's correct. What I just read to you, that wasn't incorrect up here, but this is the instruction that was given that includes this concept of reasonable mistake. And the instruction was, at all times, material herein, there was in full force and effect the statute of the state of Indiana, which is the self-defense statute. And we already reviewed this. Section 2 of 3541.32 says you're justified to use reasonable force to protect yourself. And it says, however, you're justified using deadly force only if you reasonably believe your force is necessary to prevent serious bodily injury or to prevent a forcible felony. So by giving that statute to the jury, the concept of reasonable mistake has already been addressed. And this is what I like about this instruction and this discussion about the instruction is it reveals some of the philosophy of self-defense law. This is something we as gun owners need to understand, and our legal teams, our defense attorneys need to understand and argue strongly. And what it says here, this is the appeals court explaining. The language of the statute includes the concept of reasonable mistake as to the use or threat of force or the imminent danger of bodily injury. You can make a mistake in assessing the degree of use or threat of force and what that danger is to you, as long as it's a reasonable mistake, a reasonable person. Think of the guy who puts their hand in the pocket and says they're going to shoot you. You really don't know if there's a gun in that pocket, but it would be reasonable to believe that you're going to be shot, even though you don't know for sure. So what they're saying about the self-defense law is that the concept is inherent within the words reasonably believes. They have to be read together. Reasonably believes. The lay usage of the word belief, it includes a margin of error for mistake. An assertion that one believes something is true is not a statement that it is in fact true. Inherent in the use of the very word belief is the concept of perception, how one perceives the data which forms the basis of the belief. Its coupling with the qualifying adjective reasonable strengthens the concept of error inherent in a belief. If belief meant truth and did not include the possibility of error, the use of the word reasonable would be superfluous, would be redundant, unnecessary, because the truth is absolute. There's no such thing as a reasonable truth, but there is a reasonable belief. And that's why the statute says you're justified using deadly force if you reasonably believe. It doesn't say if you certainly know, if you confidently are certain. That's when you're allowed to use force. No, it doesn't say that. It says you're justified to use deadly force if you reasonably believe. And remember from the Antonio Turner case, you have to be subjectively and objectively reasonable in this belief. You have to genuinely believe you're going to be hurt. And then a third party, a reasonable, prudent person in your shoes, knowing what you knew given those circumstances, would also believe it. Those two things establish subjective and objective reasonableness. You genuinely believe it, and somebody else, a reasonable person, would agree. That's what's required to be justified to use deadly force. You don't have to be certainly confident or confidently certain. No, that is not required. Inherent in self-defense law is this understanding that basically you don't have to be right. You have to be reasonable. And this jury instruction and this dialogue about that instruction does a really great job of helping all of us understand there's a degree of flexibility here in assessing somebody's use of force. Okay, let's wrap up this video by talking about the key principles and precedents. What are the lessons? What did we learn from this? There's really, in my opinion, two key things that we want to take away from this particular case. Number one, deadly force may only be used to prevent injury, not to arrest somebody, not to hold somebody or prevent their escape. It can be used to prevent injury, the use or threat of force where there's an imminent danger of injury, forcible felony, but it can never be used by a non-law enforcement citizen to effect an arrest to prevent the escape. So that's lesson number one. Absolutely important that we remember that. Number two, this concept of a reasonable mistake. The idea that a mistake is possible is built into the justifiable use of force statute. We have that phrase, reasonably believes, that your force is necessary to prevent serious bodily injury to yourself or someone else, or to prevent a forcible felony. This phrase, reasonably believes, it includes the concept of a reasonable mistake as to the use or threat of force or the imminent danger of bodily injury. The idea of a reasonable mistake, this concept is inherent within the words reasonably believes, and they have to be read together. And so if you remember back in the Antonio Turner case, if you watched that video, the prosecutor kept saying, well, Turner didn't know. He didn't know Briscoe was in the car. He didn't know Briscoe had a gun. This was one of the key points of that case. Turner didn't need to know. He needed to reasonably believe, and inherent in the concept of reasonably believing is the possibility that he could be wrong. But he would still be lawful. He would still be justified if that belief was reasonable. That is the other big lesson from this case. I would caution us not to try to take advantage of that, but be aware of it. We can't be any more loose or reckless or impulsive in our use of force because there is this so-called margin of error in the phrase reasonably believes, but at least we know we can be a human being and maybe even possibly make a mistake. But if we genuinely believe we need to protect ourselves or our loved ones, then we've got to be willing to take that risk, to take that action, sometimes when we can't know for sure. And that's going to require some mental prep on your part. That's going to require some study, some education. That's why the USCCA exists. If you go to my website, myergo.com, at the very top of every page, you'll see a USCCA banner there. You should click on that because if you read the articles in Concealed Carry Magazine, you're going to see stories of people that had to make these decisions. Sometimes they got it wrong. But the more we read those stories, the more we understand where the boundaries are. Where's the threshold? What are we allowed to do? Well, it's hard to know that. It's hard to know how the legal system treats this idea of reasonably believes if we've never read these stories or watched videos analyzing or breaking down these use of force cases. So it does require a little study on our part. There's a burden on you. You have some risk. You have some responsibility as a responsible gun owner. You've got to spend some time studying this subject matter so you have a pretty good handle on it. But that's the two big lessons from this case. I hope you found this valuable. If you have any questions at all, reach out to me through the Ergo website, Indiana Responsible Gun Owners, myergo.com. Let me know what you think. And above all, keep learning, keep training. Get smart, and let's stay safe. Thanks for watching.